you wanted to add?
No, nothing further.
Good. Thank you very much indeed. Mr. Randall.
My lords, the parties agreed in this case for their disputes to be resolved by the Beth Din in accordance with the rules and procedures of the Beth Din. And pursuant to that, they then agreed to confer broad powers on the Beth Din to decide their dispute in accordance with Jewish law, notwithstanding that English law is the governing law of the contract, and for the sake of compromising or honesty. Principally, the issue that arises on this appeal is a question of construction of the agreement between the parties. What the appellant asked the court to do on this appeal is to disregard the parties' agreement as to the powers available to the Beth Din, which all parties understood and acted upon, and to substitute the fallback provisions of the Arbitration Act, which the parties had contracted out of. The appellant makes two arguments, and I'll take them in reverse order. First, that the parties cannot agree powers which are wider than those contained in the fallback provisions of section 57(3) of the Act. In my submission, this is clearly wrong. It is contrary to the purpose and wording of the Act and is not supported by authority. Secondly, the appellant argues that the parties' agreement means that no award is ever final and binding. In my submission, this is not the effect of the arbitration agreement. On the true construction of the arbitration agreement, the parties have agreed that the Beth Din has a wide power to review its own awards and to make changes to those awards. And that power is not subject to a time limit. However, that does not mean the Beth Din retains jurisdiction indefinitely. Once Beth Din has addressed all issues before it, and there is no outstanding review, the Beth Din's award will be final and binding, and judgment upon it can be entered. I intend to structure my submissions in 4 parts. First, I will briefly return to certain points of context in which this appeal arises. Secondly, I will return to the purpose and statutory framework of the Arbitration Act and how Section 57 fits within that framework. Thirdly, I will address the second ground of appeal, that powers under Section 57(1) must be limited in scope. And fourthly, I will address the first ground of appeal, that powers under Section 57(1) must have a specified deadline. As my lords know, this appeal arises from an arbitration conducted by the Beth Din of the Union of Orthodox Hebrew Congregations. The Beth Din is a Jewish religious court that determines issues arising within the Jewish community according to Jewish law and in the terms of the arbitration agreement between the parties for the sake of compromising or honesty.
Only the agreement says according to the Jewish law and according to the laws of the country. It's both.
Yes, my lord.
Oh, so.
But principally, the law that is applied in determining the issues between the parties is Jewish law, and the reasoning.
Why does that matter though? Because nobody's adduced any evidence of Jewish law, so it must be the same as English law.
For your purpose, yes, my lord. That's right. I'm not saying that it's an issue on this appeal whether Jewish law is different from English law.
You mentioned it twice already.
Yes. What's its relevance?
My lords, the relevance is that this was an informal, an arbitration which was somewhat different to what might be seen in a usual more commercial style arbitration, applying English law, where the procedures and rules of an arbitral tribunal might be more familiar to parties acting under English law or within the courts. The relevance is the overall arbitration, which was being conducted according to the Beth Din's rules and procedures, and that's a much less formalistic approach than normal, which can be seen in the fact that the respondents to this appeal were not represented in front of Beth Din there are no formal statements of case and no applications.
Can I just, oh, sorry to interrupt. It was two questions we put to Ms. Binney, which was, first of all, is this ad hoc or referral agreement? First of all, do you call it an ad hoc agreement, or is it a referral agreement, or does it matter which it is?
In my submission, it doesn't matter what it is.
Is this standard wording for Beth Din's?
My understanding is it follows it was provided by Beth Din and follows similar wording to other agreements.
But Ms. Binney said there's no evidence about that, and it seems to be right. And Ms. Binney complained about your clients contacting the Beth Din unilaterally, and you pointed out they did the same thing. Is there any evidence about how these arbitrations are normally conducted?
Yes, my lord, there is. And I was coming on to that. It's at
sorry to take down your...
It was coming next. Tab 10 of the supplemental bundle, which is page 51. Tab 10 starts at page 46, but I can take you to 51. This is the second witness statement of Mr. Hiller. Paragraph 25. It says, whilst it may not be the norm among secular commercial arbitration bodies to communicate with the parties both jointly and individually by phone and email, it take relatively long amounts of time to correct an error in their award, I'm instructed that this is not unusual in such proceedings. And then on page 50...
Well, who instructed him? He doesn't say he knows. Is that Mr. Gluck who instructed him?
No, this is the solicitor for the respondents.
Yes, and he says, I'm instructed, so he doesn't know anything about it, but he's saying, somebody else has told me, I've been instructed. Well, the person who's instructed him, I thought, not Mr. Gluck, Mr.
Endzweig.
Yes, but she's instructed him, has she?
Yes.
Why didn't she make a witness statement saying this is how I normally do it? I usually ring them on a Monday after something.
Yes, my lord, I appreciate all of the witness statements in these proceedings have been provided by solicitors.
If you wanted us to look at paragraph 25 and
29. Which sets out that in this particular arbitration, there were unilateral communications between the Beth Din and both parties.
Yeah. Thank you.
The background.
Just tease it out a little bit. You seem to be suggesting to us that we should take a different approach to this arbitration than we would in relation to a quotes commercial arbitration. But this is a commercial agreement between parties subject to English law with an arbitration clause in it, and they have chosen to refer their dispute to the Beth Din. And then we have a specific agreement which expressly states that it is subject to or valid according to the Arbitration Acts. And it's also makes reference to also to English law, and it's not suggested that Jewish law is relevantly different. So in what way should we view this other than we would review any agreement to arbitrate subject to the Arbitration Acts?
My lord, I'm not suggesting that the approach should be different. All I'm saying is that the powers that have been agreed for the Beth Din might not be those commonly seen amongst commercial arbitration institutions. What that doesn't mean is that because powers are usually within commercial arbitration institutions relatively familiar and often don't stray that far from the default provisions, that is something which the parties can't agree to in circumstances where they agree to a different type of arbitration.
I don't think any part of the appellant's case has been directed at what other parties might, other commercial bodies might provide for. They're looking at what are the limits of the powers under the Act.
My lord, to some extent, that is correct, but part of the appellant's case is that a tribunal cannot, as a matter of law, review its own decisions. Now, clearly, parties can agree, as a matter of contract law, that a tribunal would have that power. So, the relevant question is, starting from the parties' agreement, can that power be agreed? Is there any mandatory provision within the Act which prevents the parties from agreeing it? And the point I'm simply making is that whilst that might be unusual to agree such a power, the point I'll come on to make is that there's nothing which prevents the parties from agreeing.
No, but the question is, can that be provided for consistently and not, as opposed to repugnantly, without agreement that that the award will be final, and their agreement that their arbitration will be under the provisions of the Arbitration Act, rather than some
My lord, there are
contractual dispute resolution mechanism.
My lord, there are 3 points. First is to what extent can parties agree that a tribunal has a power of review by which it can change its decisions? On that point, I say that the power for parties to agree that is unlimited and not in any way circumscribed by the Arbitration Act. The second question is whether that review power needs to have some sort of deadline. That's the first ground of appeal. And I will come on to why I say that the arbitration agreement can be construed so that there is such a final and binding decision at the conclusion of the arbitration. The third question, which arises from my lordship's question, is might this be a case in which the parties have agreed a contractual dispute resolution mechanism which ultimately falls outside of the Act?
That's your respondent's notice point.
Yes, my lord. There's a point that was also raised by Lord Justice Mayles in his permission to appeal decision, that the parties might inadvertently have, by their agreement, contracted out of the Act. The decision on that's at tab 7, page 53 of the core bundle. And in the third paragraph of his decision, he says the appellant submits that if the appropriate analysis of the agreement is not an arbitration agreement at all, the effect is to revive clause 22.2 of the SPA. That may be the right analysis, but it seems to me that this does not necessarily follow. It may be that the parties have perhaps inadvertently contracted out of the Arbitration Act altogether.
And the effect would then be that the rulings are enforceable, if at all, under the contract law.
Yes, my lord. If I could ask you to turn up tab 33, since we're on this point of the authorities bundle.
Page
442.
442.
Yes.
Thank you.
The 819 following there. 819 deals with the summary procedure under section 666, which is what was utilised in this case. Section 820 then deals with the situation in which an agreement between the parties, for whatever reason, does not fall within the Act. And in those circumstances, there's an implied obligation to perform the award.
But this agreement was intended to fall under the Act.
Yes.
And the only question at the moment is those words after the comma in one line. You know what I mean? The words and have a can amend, add to, and change.
Yes.
The only question is A, what do they mean?
Yes.
And B, are they valid? If they mean X, they may be consistent with the Arbitration Act. If we can't get them to mean X, we put a line through them.
Well, the alternative, my lord, would be to put a line through the sentence before, which says that it's valid according to the Arbitration Act.
Okay, you can do it that way, yes.
And then it would fall to be a contractual dispute mechanism, which is an arbitration, but not an arbitration within the Act. And
So if you're going to
then be
You'd also need to put a word through the word final in clause 22.
I don't believe so, my lord, because clause 22 of the SPA requires the parties to submit a dispute to the Beth Din so that it's finally resolved by arbitration in accordance with the rules and procedure of the Beth Din, and judgment upon the award rendered by the Beth Din may be entered. That, in my submission, would be consistent with what is envisaged at paragraph 820 of Russell on arbitration, that it would be a contractual arbitration outside of the Act, which could be enforced by a contractual claim on the basis of an implied obligation to perform the award.
So the choice then, you say, is to strike out one half of one sentence or the whole of a previous sentence.
Well, my lord, if my lord's reached the conclusion that there is no sensible construction, then that there's no sensible implied term, and that the whole thing is either repugnant or doesn't work, then yes, I think then the options are to say that actually the parties hadn't agreed anything and the Arbitration Act applies, or to say that this was an agreement falling outside of the Arbitration Act.
Okay, and you'll tell us how the hierarchy of repugnancy works, how we decide which bit is more repugnant than the other bit.
My lord, my primary submission will be that the agreement can be sensibly construed and given effect to in accordance with the terms of the Act. My lords, as you're aware, returning to the context briefly, this dispute arose in December 2019 and was referred to the Beth Din. Subsequently, various issues relating to the amounts payable under the SPA by the respondents were raised with the Beth Din, and there were a number of hearings before the Beth Din. And essentially what the Beth Din did was keep the profitability of NetPEX under review, and that can be seen in the first and second awards. I could just take you to the first award to give some context to the time that passed on page 2, tab 1, page 2 of the supplemental bundle. The second paragraph you see in the square brackets, since it was agreed that Party A would submit the accounts and the P&Ls to Party B every month. It was essentially kept under review whilst NetPEX was continuing to trade.
I'm not with you now. Are you saying, no, I'm just not with you, I don't understand your submission. Can you just run that by me again, please, what you're saying?
It was originally raised, the issues were originally raised in 2019. There is a period of
2.5 years.
4 years until, until the Beth Din reached a final conclusion. During that time, there were a number of different hearings. The respondents were ordered by the Beth Din to provide monthly P&Ls to the appellant.
P&L being?
Profit and loss statements,
Right, thank you.
accounts. And it was kept under review before the arbitration.
Where are you getting that from this page?
It's in the square brackets, the third sentence down. It's also referred to in the second award.
Well, I'm on page 2.
Yes. The second paragraph.
It is agreed with respect to the breach of the party A's fulfilled the conditions. This is all about whether those relevant conditions about him supplying the accounts. There must have been a provision under the contract for him to supply the accounts.
My lord, not quite. There was a provision within the contract for information to be provided, but the provision of accounts was under the auspices of the Beth Din.
So I'd understood you to be saying that this award was suggesting that the rabbinical court or Beth Din was keeping it under account and requiring the account.
No, my lord.
It's not. This is just saying what each party was supposed to do to the other party in order to comply with the conditions, isn't it?
Not to comply with conditions within the SPA, but this is what was ordered by the Beth Din over a period of time.
So it was agreed between the parties, was it? Or agreed with the Beth Din? It's
Yes.
an incredible way to write, no disrespect to the Beth Din, but looking at the words on the page, I can't get it out of the words on the page, can I?
No, my lord.
Right, so it doesn't help us then. We've got no evidence as to how that came about.
Subsequently, on the 15th of March 2024, in this ruling, the Beth Din dismissed various arguments raised by the appellant and determined that the respondents were entitled to a price reduction under the SPA, but that there would need to be a further hearing to calculate the amount.
Yes.
As explained at paragraph 15 of the second statement of Mr. Hiller.
Just reading this, not reading what other people think this means. I just read I don't know if it was in Hebrew or English, but I read this, and to the non-commercial lawyer who's not familiar with Jewish culture, it says two things to me. He's complied with the conditions at least for most of the time, but we've got to sort out the amount. That sounds to an English lawyer, or even the Welsh one, as broadly liabilities established and quantum to be determined. That's what this appears to say.
Yes, my lord.
So that's that then. This wasn't a document recording determination of the dispute between the parties. This can only have been dealing with one bit of the dispute, whether or not the conditions entitling him to a deduction to be calculated have been met.
Yes. And to be clear, under the Arbitration Act, Part 47, an arbitrary tribunal is subject to the agreement of the parties, able to make awards on different issues.
Yeah.
As explained at paragraph 15 of Hiller 2.
Paragraph 15 of
Mr. Hiller's second witness statement, which is at tab 10 of the supplemental bundle.
which is page
49.
Thank you.
If I could take you back to 48 to provide some context. Paragraph 13 explains that an issue originally arose as to whether the profits of NetPix and another business owned by the respondents called Midos, whether the profits from the Midos business should be included in the profits of NetPix when calculating the consideration due under the SPA. As explained afterwards, the Beth Din made a determination in 2020 that the profits of NetPix shouldn't be included. And then, as explained at paragraph 15, the Beth Din, after its award, then requested details of all information related to the business performance from the accounts manager for NetPix. And in the second award, dated 28th of May 2024, the Beth Din used the profits for the entire business, including NetPex and the Midos business, to calculate the amounts due under the award.
So who supplied the wrong information? Your client, or your client's account manager, or the other side?
My lord, as explained there, the account manager provided the information for the entirety of the
account
business.
Manager employed by which of the two sides? It's impossible to work out.
Neither side is. He's employed by NetPex.
Oh, I see. Right.
And as explained at paragraph 17, on the issue of the second award on the 28th of May, Mrs. Endzweig noted that the calculation included the NetPex profits, which the Beth Din had previously said should not be included, and did not deal with certain other issues which had been raised with the Beth Din in the arbitration. Those were the issues raised by Mrs. Endzweig a matter of days after the award had been issued. As explained at paragraphs 20 to 23 of the judgment, there were subsequently a number of communications between the Beth Din and both parties, including, this is paragraph 22 of the judgment, which is page 41 of the court bundle, a letter on the 25th of June from the appellant's rabbinical attorney, Mr. Davidovitz, which is Honour Judge Kaiser describes in paragraph 22 as a full-scale blast of the findings and reasoning in the award. And the text of some of that letter is set out at paragraph 22. And the final paragraph of that quotation is that I ask the court to carefully consider this matter and to explicitly explain to the parties that it has been shown beyond any doubt that the condition has never been fulfilled and that the defendant consequently has no rights of deduction, being obligated to pay the full amount. And as His Honour Judge Kaiser then says, so that letter, which was written on behalf of the claimant, was not a request for clarification, it was a request for review and whole-scale alteration of not only the second award, but the first award. So as at the 25th of June, the appellant was proceeding on the basis that the Beth Din did have power to review its own awards. That then changed in October 2024, when the appellant instructed solicitors and wrote to the respondents demanding immediate payment of £459,228. That was met with a response that the award made by the Beth Din was under review. And the appellant then asked the court to exercise its discretion under section 66, because 66 provides that the court may enforce an award. And that application was supported by a witness statement, Mr. Fulder, which, as Honour Judge Kaiser found, failed to discharge the duty of full and frank disclosure. On the 11th of February, the Beth Din issued the third award. Now, there was some discussion earlier as to whether what the third award deals with. The third award is at tab 11 of the supplemental bundle. And the slight oddity in this case, of course, this came shortly before the hearing and after evidence had been filed in support of the application, so it's not dealt with in detail by any of the evidence. But the third ruling, the Beth Din did not accept that the calculation of its award should be reduced by the NetPex, by the inclusion of the Midos profit. So that's not what it reduced the award for. The award was instead, in respect of two elements. One is the corporation tax payment, which is referenced in the email of 6th of June from the Beth Din. And the second is in relation to certain expenses which had been paid by the respondents in relation to NetPex's business. And those are all issues which arise in the Section 68 claim by the appellants.
So is that the corporation tax? Is that the 93,000, and the expenses is the 106,000?
Yes, my lord. That's what I understand.
So are you building up to saying the corporation tax is something additional and can be dealt with? And what's the position on the expenses? Can you produce new evidence to say, well, I paid some more money, I'd never told them first time round? This has got nothing to do with the claim that the wrong profits are included in the accounts, you say? I mean, I'm not sure what this is building up to.
Well, my lord, there is obviously a question of what issues have been raised for resolution by the arbitration. In the Section 68 claim, the respondent's position is that these issues were validly raised and that the Beth Din had jurisdiction to determine them.
On what basis? That it was a change to the original award? That it was the determination of an undisputed issue? And they just do whatever they like. I can't. I'm trying to put this into the conceptual framework of that power that you've got to add, amend, and change.
Well, there are in fact three separate powers.
Mm-hmm.
The first is the power to decide any disputes between the parties, and that's consistent with the power in Section 47 of the Arbitration Act that an arbitral tribunal can make awards on different issues. So, my lord raised
the for the amount of shares, isn't it?
well,
they decided he had to pay another 459,000 for the amount of these shares.
yes, that was
so
one
the
of the issues raised on the arbitration. But the issues of whether there was a sum of corporation tax which had not been paid by the appellant, which should have been deducted, was also raised.
And what about the expenses? Isn't that part of the issue, and nobody raised it in the first two?
Well, my lord, the respondent's position on the Section 68 claim is that all of these issues were raised. The appellant's position is that they weren't.
Is the Section 68 the thing that's happening in April?
Yes.
Then I'm not sure how this is helping me to understand this appeal, but anyway, there we are.
Well, my lord, the difficulty of the issue is this. This, as has been discussed, there are various powers available. If we set aside the arbitration agreement in this case, if we're just looking at the default powers, the arbitral tribunal could be correcting an award, it could be adding to an award, or it could be making an award on a different issue which it has not previously determined under Section 47.
What I wanted to know is what you're saying this is.
Well,
in relation to A, corporation tax, and B,
yes,
the expenses, because you told me a short while ago that the contact was all about the Midas profits, but that is a red herring, it seems. It's nothing to do with the third award of the Midas profits, unless that is still outstanding, and unless that's the next fourth award that we're going to get. So at the moment, we're back to the corporation tax, which I think you said was the one referred to in the email of the 6th and expenses, which we heard about for the first time a little while ago. And as I say, what would help me, personally, I'm struggling with this, is if you could help me with understanding what you're saying each of those is under the agreement, or whether I don't need to know whether it's any of those things under the agreement. I mean, why are we going through these details?
Well, my lord, the point is this: is that even if there was no power to add to a judgment, as is argued by the appellant, the Beth Din still retains jurisdiction to decide issues validly raised upon it, which have not been dealt with in a previous award under Section 47. So the outcome of this appeal does not finally determine whether or not the third award is liable to be set aside.
But that isn't before us.
No,
The only issue before us is whether or not the second award was properly enforced as of November 24.
Yes, my lord, that's right.
Anyway, you've had a number of questions. Do you want to say where are you now?
My lord, I'm just turning to the second part of my submissions, which is on the purpose and framework of the Act. I just conclude the context by saying that there would be a substantial injustice in this case if, relying on the Beth Din's own understandings of its powers, the respondents were shut up from raising valid points about the Beth Din's award. As to the purpose and framework of the Arbitration Act, this is set out at paragraphs 24 to 29 of my skeleton. As has been seen earlier, Section 1 of the Arbitration Act sets out the core principles of arbitration, which include that parties should be free to agree how their disputes are resolved. Section 4 of the Arbitration Act, which is at tab 18 of the bundle, page 337, gives effect to this principle of party autonomy by distinguishing between mandatory and non-mandatory provisions. There are relatively few mandatory provisions which parties cannot contract out of. When the arbitration bill was placed before Parliament, it was supported by the report on the arbitration bill by an ad hoc committee chaired by the Right Honourable Lord Justice Saville, which is at tab 32 of the bundle.
Page?
It starts at page 377. If you could turn up page 381. And in respect of clause 1, at paragraph 19 of the report, the committee wrote that the second principle is that of party autonomy. This reflects the basis of the model law and indeed much of our own present law. Under an arbitration agreement is a consensual process. The parties have agreed to resolve their disputes by their own chosen means. Unless the public interest otherwise dictates, this has two main consequences. Firstly, the parties should be held to their agreement, and secondly, it should be in the first instance be for the parties to decide how their arbitration should be conducted. And the final sentence of that paragraph, again, as appears from the mandatory provisions of the bill, there are some rules that cannot be overridden by parties who have agreed to use arbitration. In general, the mandatory provisions are there in order to support and assist the arbitral process and the stated object of arbitration. Turning over at page 382 in relation to the mandatory and non-mandatory provisions, the committee explained that this provision is designed to make clear that the bill has certain provisions that cannot be overridden. The clause also makes clear that the other provisions of this part can be changed or substituted by the parties and exist as fallback rules that will apply if the parties do not make any such change or substitution or do not provide for the particular matter in question. In this way, in the absence of any other contrary agreement, gaps in an arbitration agreement will be filled. In relation to that, the principal point is that unless there is a mandatory provision saying that the parties cannot agree something, the parties can agree what they like. a non-mandatory provision, there does not need to be a corresponding non-mandatory provision within the Act for the parties to agree a different process or procedure. And this comes back to the point I was making at the outset about the fact that this is a less formalistic arbitration than what might be commonly seen, because the purpose of the Arbitration Act is not to stop parties from agreeing that. And if I could just ask you to turn to page 396, where this point is again made in respect of clause 30.
This is still in the report, is it?
Yes.
Yeah, thank you.
In respect of clause 33 of the Act, the committee says that paragraph 151, starting at the second sentence, the advantage of arbitration is that it offers a dispute resolution system which can be tailored to the particular dispute to an extent which litigation finds it difficult to do. Thus, depending on the nature of the dispute, there will be numerous ways in which the arbitration can be conducted. It is quite impossible to list all the possible variants and to set out what may or may not be done. Indeed, any attempt to do so would defeat one of the main purposes of the bill, which is to encourage arbitral tribunals not slavishly to follow court or other set procedures. It follows that the only limits can be those set out in the present clause. And they go on in 152 to say that they would hope this does not discourage people who are not lawyers from carrying out arbitrations. Paragraph 153, they say at the start, sometimes the parties to an arbitration employ lawyers who seek in effect to bully a non-legal arbitration, taking a course of action which is against his better instincts by seeking to blind him with legal science to get their way. Final sentence of that paragraph. This part of the bill is designed to prevent such bullying and to explode the theory that arbitration has always to follow court procedures. If an arbitrator is satisfied that the way he wants to proceed fulfills his duty under this clause and the powers he wants to exercise are available to him under the following clauses, and he should have the courage of his own convictions and proceed accordingly, unless the parties are agreed that he should adopt some other course. So the principle is that the parties can agree whatever they like, subject to two limiting factors. One is the mandatory provisions of the Act, and two, in my submission, is the concept of illegality, which obviously does not arise on this appeal. But other than that, it is a matter of contract law what the parties have agreed. And the non-mandatory provisions of the Act do not define the powers that can be given to an arbitral tribunal. The provision in question on this appeal is, of course, section 57 of the Act, which is at tab 24 of the authorities bundle. And this is, of course, a non-mandatory provision, as is expressly stated in section 57.1. Section 57 is complemented by section 58, which explains that unless otherwise agreed by the parties, an award made by the tribunal pursuant to an arbitration agreement is final and binding, both on the parties and on any persons claiming through or under them. As my learned friend has adverted to, I fully accept that for an arbitration agreement to be an arbitration agreement under the Act, it must result in a final and binding decision. And the authorities on that clearly say that the words "unless otherwise agreed" cannot prevent that being the case. The two authorities which are in the bundle, which deal with this point, are, however, considering very different contractual provisions. One of those is the case of IS Prime and TF Global Markets UK Limited 2020, East Wales High Court's 3375 comment 56, which is tab 13. And if I could just ask you to stand out to show you the sorts of provisions which have been held to not fall within section 58. It starts at page 203. But if I could just ask you to turn to page 206, which sets out the clause which was being considered in this case, paragraph 2. Towards the end of paragraph 2, the relevant clause in question was section 7.7. Section 7.7 provides that any dispute, controversy or claim between the parties to the sale agreement arising out of or relating to it shall first be submitted to non-binding arbitration. So what Mr. Justice Baker determined in that case is that if you've agreed that you're submitting something to a non-binding arbitration, that's not an arbitration agreement within the meaning of the Act. But that principle is not disputed. Coming then to the appellant's grounds of appeal, and I intend to deal with the second ground of appeal first because I think it can be dealt with more briefly. The appellant argues that the power under section 57(1) must be limited to corrections equivalent to the fallback provisions contained in section 57(3)(a) of the Arbitration Act. In my submission, and that's set out at paragraph 62 to 64 of my skeleton, there is no basis for that argument. At paragraph 33b of the Learned Friends skeleton, it is submitted that there is no authority on the question whether the parties can agree a power of correction that allows changes more wide-ranging than those permitted under section 57(3)(a). In my submission, that's not correct. I could ask the Lordships to turn up the case of Daewoo Shipbuilding, which is at tab 12 of the bundle, starting at page 173. The passage you were taking to earlier, which is at page 191. This was again dealing with whether an application to the tribunal is an arbitral process of appeal or an application under section 57. And paragraph 53, starting halfway down, on the contrary, I considered the ordinary natural meaning of the language in the context of a statutory provision that draws a delineation between an appeal or review and a correction, is that it is a reference to a process by which an award is subject to an appeal or review by another arbitral body. This is supported by the fact that under section 57, and absent any contractual provision permitting it to do so, the tribunal cannot reconsider whether it reached the correct decision or indeed change its decision, given that it has already delivered its award. So clearly there, Mr. Justice Baker considered that the parties could agree a contractual provision which permits the tribunal to review its awards.
Mr. Justice Brown, I think.
Apologies, yes, Mr. Justice Brown.
So the structure is, it's not that 57 says you can make powers of correction, and if you don't, you've got these powers. The law permits parties to agree what they want, and that can include arbitration, tribunal review their awards. But in relation to correction powers, if you haven't made a correction power, then you've got default powers. That's the way it works. So it's possible to be outside and broader than section 57, because it's not intended to define what you can agree. It's intended to define the default powers if you haven't agreed a particular thing.
Yes, my lord. there are a number of routes to the same conclusion. The broad proposition is parties can agree that a tribunal has a power of review. Now, one can either say there is no provision in the Act relating to that, or one can say that is an arbitral process of appeal or review, as referred to in section 72 of the Act, or one can say, well, that falls within section 57.1. As the logics were taken to earlier, there is authority, there is a trend in the authorities to saying that, and this is the case of K&S, which is at tab 8, starting at page 134. Paragraph 18 of that judgment at page 138 of the authorities bundle. There is a trend towards saying that an arbitral process of appeal or review is by another body. And that's what Mr. Justice Tier held in that case. There is no statutory language in the Arbitration Act which says that's the case. That distinction, however, is there is no issue with that distinction, so long as any process of review by the same arbitral tribunal falls within section 57.1. And my submission is that section 57.1 is easily broad enough to allow for any review to the same tribunal.
Well, there's two arguments. Firstly, it doesn't have to do that anyway. They can agree it if they wish. Yes. But secondly, if you want to look at section 57.1, correction, you say, is broad enough to include review.
Yes, my lord.
It's always two-track argument, isn't it?
Yes, my lord. The mischief in K&S and a couple of other cases which have been discussed is the time limits in section 72 and 70 of the Arbitration Act. And as my learned friend mentioned earlier, it is notable that section 70 has recently been amended by the Arbitration Act 2025 to make clear that there are in fact two different time limits under an application under section 57. So under section 70 now, which is tab 29, the new section 73A provides for a time limit relevant to an application for a material correction or material addition to an award to be different from that of a correction to an award or an addition to an award. So now that was the way in which the authorities had dealt with the issue previously anyway, but is now part of the statutory language. So you have a twin track now, which is that you have an appeal or review and additional material changes, material corrections or additions. Those are subject to the same time limit, which is that the time limit for the challenge to the courts arises when the application is disposed of, or minor correction slips, which are dealt with, in which case you have to appeal to the court within 28 days of the award, rather than the tribunal's judgment on the application.
While you're at section 70, if you're right that there can be a right of recourse under section 57, which includes a wide review and has no time limit, then you would never be able to challenge the award.
My lord, the time limit I will come to, but I do think those two issues are distinct. There is the question of how wide is the scope of a power, and then when must that power be exercised. There's no issue arises from having a wide review power. It could be, as I think was raised earlier, there could be an agreement between the parties that the parties have 14 days to raise any issues they have with the award, and the tribunal will provide a further judgment within a further 14 days, for example. Then there would be no issue with the timing of any challenge.
Well, I asked it because we have section 78.
Yes.
But obviously, if your submission is that under section 57 you can not merely correct, but you can also review, or under your contractual under section 57(1) on your contractual basis, then you have an ongoing right of review without any time limit, which would mean you can never challenge the award.
Yes, my lord, my submission is twofold. First is that it's not the scope of the power that the tribunal has. It doesn't matter whether it's a power of review or a power of correction. The time limit question, I will come on to address, but in my submission, that there must be an end point. I accept that limitation, but in my submission, that point arises when the arbitral tribunal, when the Beth Din in this case, has dealt with the issues, all of the issues before it,
So you,
and has.
It never will, because you've just shown us, for example, something that was dealing at the second stage. They were very upset because they'd included the wrong profits. You then showed us the third tribunal who said, oh no, they haven't taken the expenses into account. Two questions: why can't they raise something again and say you've forgotten some other expenses? And secondly, why can't the other side go back and say you've got this round your neck? You should never have allowed the expenses. You should have never allowed the tax thing. Each side can go back and ask you to correct the correction.
Yes, my lord. 2 points in respect of that question. The first is that it is true that any arbitral tribunal could keep going forever and ever. I mean, that hypothetical doesn't arise simply on the basis of the review power in this case. As I've mentioned, section 47 allows an arbitral tribunal to make multiple awards on different issues. An arbitral tribunal could.
It's the amount of money that should be paid. And on the third go, which was the 11th of February 2025, they allowed a new issue to be raised. Certain expenses had been already paid and not taken into account. So why can't you have a fourth one saying, well, in fact...
Well, you could do, but that could happen. That could happen under any arbitration. My lord raised earlier the question of set-off. And an arbitral tribunal can deal with a claim and then can separately deal with a counterclaim and an additional claim. Those things can be dealt with sequentially. So there is always a possibility that further issues arise in an arbitration. And arbitration, as with court proceedings, could take a long time.
I think my lord's point is that you're right, you can divvy up issues, but if you make an award, then that can be enforced,
yes,
even if there's going to be perhaps some money coming back the other way under a later
yes,
award. And what the objection being put to you is that here you just get no finality.
Yes. The second point, which is whether or not there is finality in this case, and in my submission that there is under the arbitration agreement, and such finality comes when the Beth Din has undertaken the review that it has been asked to undertake. In this case, it was asked to undertake a review shortly after the award was issued. It did so.
But not on the issues are not solely on the issues that it was asked to, because you told us that the third award was on something totally different, expenses. So that must have either, well, I don't know when that was asked for, but you had the award. The issue was how much should they pay, and the answer was 459,000. There's not a new or a different issue. There's a different way of calculating the money paid. There was a request for review on corporation tax, and they've looked at the MIDOS profits and they shouldn't have. We don't know what's happened to the MIDOS profits points. That may well lead to the fourth award, because that may or may not be outstanding. But with the third award, they took into account expenses. It's not a new issue or a separate claim. It's just calculating the same issue they've already decided, but with different figures.
Yes, my lord, but if in this case the appellant hadn't appealed the judgment and hadn't issued Section 68 claim, no further review was requested by either of the parties.
Not yet.
Not yet, it can be though.
At the currently, while the award has not been enforced, yes.
But what it means is, I think, what you're saying is that you don't accept that the words mean what they say, because you don't accept. You're submitting to us that the words "at any time" don't mean at any time. There's some limit on them.
My lord, my submission is that there must be some limit. Yes.
Can I? Oh, sorry. Can I just ask the point I put to Ms. Binney about Section 57(4)? If you have to have some sort of limit on when you can exercise this power of review, is there any way in which you can read the "and to amend ... as subject to Section 57(4)? Because you've not said when you can ask for that to be carried out. And Section 57(4) then applies, and that you've got to apply within 28 days.
My lord, that is a possibility. In my submission, there is the routes to an answer is firstly as a matter of construction, secondly as a matter of implied terms, and then thirdly, if the court's view is that nothing is said on an issue, then it's to look at the fallback rules within Section 57. In my submission, if there is to be implied into the agreement a limitation, then it is a broader limitation than those within the default provisions. And the limitation would be that it must be done within a reasonable time.
But how can you do that? And to amend and add to and change the judgment they've given at any time. So award 2, second one, they object within 7 days.
Mm-hmm.
That's fine. You then get award 3 on the 20th of February 2025. Next day, within a reasonable time, 24 hours, they say you got it wrong again.
Yes, my lord. There is though an important point, which is that the what has been conferred on the Beth Din is a power to review. There is no obligation to review, and the Beth Din is subject to the general duty in Section 33 of the Arbitration Act. To deal with matters fairly and expeditiously. So
They will do, because I put it to you, they do it on the 20th of February 2025, whatever the date was, and immediately there's a new request saying, no, you've got it wrong again. Or, no, there's more things we've thought of. They will be doing it reasonably quickly from each request for a review, because the moment there's a request for review, you go away, they review it, there's a decision on the review, and there might be a further request. You can't take the time limit for the first request for the review and somehow stop other requests for reviews after the reviews, if you follow me.
Yes, my lord, but the power is for the Beth Din to review. So the Beth Din has the power not to allow or entertain further reviews. So if the situation arose, and this is in my submission what there was reference earlier to His Honour Judge Case's judgment about declaring the tribunal functus officio. In my submission, what's being said there is that the Beth Din could say that there will not be any further reviews. It has dealt with all the issues before it. It has given its award, and it won't entertain a further review.
It did on the expenses
Yes, my lord.
years later, or months later.
Well, it wasn't months later, my lord.
I think I don't know. We know nothing about how the expenses arose. All we've been told is that the email that came, the telephone calls, and the email that came immediately after the second award dealt with corporation tax and the Smidos profits point. And then you told us this morning, and I hadn't realised until then, that the third award dealt with something else, something to do with expenses that had already been paid. And I have no idea when that was raised.
Yes, my lord. My understanding was that all three issues were raised on the calls shortly after the award was issued.
Are you saying those were applications?
My lord, this, in a sense, comes back to what I was saying earlier about it being a less formalistic arbitration than we might ordinarily expect. There are no application notices in this case, but
it just even seems to have been by one of the parties.
Apologies, my lord.
The matter doesn't seem to have been raised by any of the parties to the arbitration.
Which matter?
Any of the matters.
The matters dealt with in the third award. The Midos profits.
My understanding, all this was raised by one of the parties' wives in a phone call.
No, my lord. The respondent's position is that all of these matters had been before the tribunal long before the second award. They weren't dealt with in the second award.
No, the application to review. You're relying upon there being an application to review, as I understand.
Well, my lord, I'm not saying that there is a formal application. The power here is for the Beth Din to amend and add to and change the judgment they've given. There's no requirement for an application to be made.
Well, I think my lord put to you that he said that you could interpret this as requiring an application within 28 days. I thought you agreed with that. Well, I can't see an application.
Yes, my lord. Well, in the sense that if it is a requirement, if the default provisions within section 57(3) to 7 of the Act apply, and the requirement is that the party makes a. I mean, the requirement in section 57(3) is that the tribunal may, on its own initiative or the application of a party. My lord's point was, could you look at section 57(4) and say, well, the 28-day time limit applies to an application, but in the sense of an issue being raised, and then the time limit applying from then for the tribunal to issue judgment
That
on
would
that.
help you with it.
It does provide an answer in my submission. If what we're looking for is a limitation on when parties can do things, if one were to say an issue with an award, what it means at any time is that an issue with an award must be raised within a specified time period, and then the Beth Din has an unlimited time to give its judgment on that matter. That would be one potential answer.
Could you show me, please, the evidence, putting it as neutrally as I can, as to the point of time and the person by whom a question to do with the payment of expenses having already been made was notified to the Beth Din with a view to the Beth Din doing something about that?
My lord, there's no evidence on that point
So we've no idea when this matter was dealt with or raised.
There's no evidence on that point because when the application was made,
Which application?
so when the application to set aside the judgment of enforcing the award, the principal issue for the respondents was the inclusion of the net tax profits, and that's explained in the second witness statement to Mr. Hiller. The third award that was explained at paragraph 19. If those Midos profits had been excluded, the calculation of it was that the award would have been 10% of what had been made. So that was the forefront.
Going back to the question that I actually asked, which was about the expenses that were said to have been overpaid, you have no evidence at the moment, as I understand it,
No, my
as
lord.
to when that was brought to the attention of the Beth Din or by whom.
No, my lord.
But the award is fine because at whatever stage presumably it was brought, they must be able to do it.
Yes, my lord. As I explained earlier, ultimately that is an issue which will arise on the Section 68 claim.
Well, I'm not interested in that. I'm interested in this thing.
Yes.
And what we're told is that there's a new award dealing with something else. But there's nothing to stop them coming back and saying you still haven't given us credit for the Midos profits and you should have. And the other person turning around and saying, no, you've already effectively decided that. You can't go over that again. I can't see, because we don't know when this net expenditure thing was raised. And I can't see any resolution on the limited information you've given about the Midos profits. And it seems to me you could have more requests, to put it neutrally, for amendments, additions or changes to the award, because things that were raised earlier weren't looked at, or new things might be brought into the picture. There's nothing to stop that happening. And the real question is such a process inimical to arbitration that it means that the words either have to be interpreted differently or have to be excised, or it won't be an arbitration agreement under the Act? Or do you say, well, they so wanted to have this kind of wide power, if you're going to take anything out of the agreement, take out the words that said it's supposed to be valid under the Arbitration Act. I still think that that's the issue, and all the stuff that you told us.
Yes, my lord, I agree. I agree that is absolutely the central issue. And my position is that there does come a point when the tribunal's jurisdiction to consider issues before it is exhausted, and that is when it has dealt with all of the issues, either by way of multiple awards under section under the agreed powers to deal with different issues as allowed by section 47, or when it has dealt with any reviews or changes that are appropriate, and that at that point it would be possible to the award would be final and binding and enforceable, and after that, then once an award has been enforced, my submission would be that at that point, then the Beth Din wouldn't have jurisdiction or wouldn't be able to reconsider positions afterwards. Just one. I could ask my lords just to turn up one authority considering difficulties that might arise in respect of when exactly an arbitral tribunal's jurisdiction is exhausted. It's the case of Dawes and Treasure and Son, Business Law Review, page 676, it's tab 3 of the bundle.
Tab 3.
tab 3, and the headed argument will just turn up paragraph 26, which starts at page 45. Paragraph 26 is just Aiken heads it.
What's the issue of this? What has happened in order to understand it?
The question here was whether jurisdiction was retained after a settlement had been
So
entered.
the dispute arose, an arbitrator was appointed, the dispute was settled, and the question of liability and amount of cost of the arbitration was left to be determined by the arbitrator. So that's what was the issue, is it?
Yes.
Okay, thank you.
The point I wish to make in respect of this is brief. As Mr. Staken had said, it says at paragraph 26, the efforts of experience of counsel have failed to locate much relevance by way of authority as to when and how an arbitrator becomes functus officio. This may not be altogether surprising because arbitrations and arbitration appointments vary in almost every case. Once the arbitration is over, the parties are usually delighted not to have to revert back to the arbitrator for any reason. And then at paragraph 27, the expression functus officio is not a term of art, but in the context of arbitration it describes or implies the point at which an arbitrator has exhausted or concluded all that he or she had jurisdiction to deal with. And just briefly at paragraph 29 and little a, primarily as arbitration is usually a consensus process, one must look at the contract between the parties pursuant to which the arbitrators have been appointed to determine what the parties have agreed about when an arbitrator's jurisdiction becomes exhausted. So in my submission, that is what the question is: when exactly is the Beth Din's jurisdiction exhausted?
Mm-hmm.
And in my submission, that entails, as Mr. Staken had said, there's not a it's a nuanced issue, and in this case, it would be when there are no issues or reviews outstanding in front of the arbitral tribunal. At that point, the Beth Din would have made decisions on all of its awards, on all of the issues, made awards on respect to those issues, and judgment could be entered if those awards were not complied with.
If we're against you on that, in other words, at any time, add, amend, or change mean that it's open-ended, what then? Well, how do we decide that we strike out this deed will be valid according to the Arbitration Act instead of the amend, add, and change the judgment at any time clause according to the hierarchy? Or are there still more submissions on this?
No, my lord. My lord, if the lordships do not consider it can be resolved as a matter of construction, then the question is what is the objective agreement between the parties? What have they sought to achieve by their agreement? And the court should strive to give effect to that agreement. Set against the principles I set out earlier, that arbitration is intended to be a consensual process, principally determined by the parties' agreement. And so looking at the arbitration agreement, what the parties have decided is that the Beth Din will have a wide jurisdiction to decide the issues between it.
You go back first to the share purchase agreement, don't you? And what they wanted was for things to be resolved by arbitration,
Yes.
by the Beth Din, and to be finally resolved and to be entered in a courthouse jurisdiction. And on this basis, we're assuming that we're not persuaded by your argument that you can work out when that is, and it's open-ended. So the question then is, given that they said they wanted final and to be capable of being entered by a court, we then turn to the arbitration agreement to decide which clause should go with it.
Yes, as I submitted earlier in my submission, if clause 22.2 of the SPA, the parties' agreement was that matters should be resolved by arbitration by the Beth Din.
Finally resolved by arbitration.
Finally resolved by arbitration by the Beth Din. And in my submission, the arbitration agreement gives effect to that. If it falls outside of the Act, as I submitted earlier, it can be enforced. Any award made during the arbitration can be enforced as an implied obligation of the arbitration agreement.
No, my problem is this arbitration says this deed will be valid according to the Arbitration Act, and the assumption here is that in order for the thing to work, it's got to be final. And on this hypothesis, we've rejected your argument.
Yes.
I'm not saying that's what we're going to do. Is on this hypothesis for the moment, we've rejected your argument that is capable of being compatible with the Arbitration Act unless there's a final resolution capable of being identified. So if there's that clause in, and given the final resolution by arbitration clause, that suggests it's got to be final, which might make you think that if one clause has got to give way, it's the last half of the clause that's been an issue, the and to add, amend and change at any time clause. That's what I'm driving at, is how do I decide which of those two takes priority if I reach the stage when I think it's either or?
Yes, my lord. In my submission, setting aside the Arbitration Act, if you look at the arbitration agreement, if that agreement was placed before the court, separate from the provisions, my submission is that the court should find that the parties have agreed that an award can be enforced. All the same issues might arise to raising reviews and so on, and that process would have to come to an end. But if there was then, once you reach a point that the issues have been resolved, and there are no further reviews outstanding, the parties to the arbitration agreement could sue under the implied obligation to comply with the awards made. And the court would not, in my submission, accept an argument that the parties had not intended to be bound by it. So the court would find that there was such an implied obligation. And that the party has therefore acted in breach of its contractual obligations to comply with the terms of an award.
For my part, I see the force of Lord's point that if on this hypothesis we have rejected the attempt, or we have accepted the argument that the any time wording means that there's no finality, which makes it repugnant to the Arbitration Act scheme in that hypothesis. To make it consistent with section 22.2, you would prefer the arbitration agreement wording. But a further point, the phrase "in this deed will be valid according to the Arbitration Act" addressing the very nature of this agreement, the very nature of the referral. To strike that out in favour of some wording about the procedures to be adopted, isn't that to allow, wouldn't that be allowing the tail to wag the dog? Changing the very nature of what the parties have agreed in relation to this agreement in favour of a mere procedural wording.
My lord, that might be correct, but in my submission only takes you so far. We could enter into an oral agreement that we intend to be bound by the Arbitration Act. That would not be an arbitration agreement within the meaning of Section 6 of the Act.
But we are looking at this wording, not the oral wording of a different contract. It's not before us. We're trying to work out what this means.
Yes, my lord. But if in that circumstance we had an oral agreement as to an arbitration, that oral agreement might be upheld, notwithstanding that our agreement was it should fall within the Act, but it doesn't.
That's a situation which it was ineffective to be in accordance with the Act by virtue of that it wasn't in writing.
But in my submission, that's the same argument that's being applied here, that it's ineffective to be within the Act because it doesn't comply with the provisions of the Act. I mean, an oral agreement is one. That's the most common way in which an arbitration agreement won't fall within the Act. But that's not the only possibility.
But we could put it another way. Are the parties not saying in that sentence, and this deed will be valid according to the Arbitration Act, that their intention is that everything that they are doing will make this a valid arbitration agreement under the Arbitration Act, and it should be read in that way? Because they wouldn't need to say that otherwise. And so when you look at later provisions, you have to read them to render in a way that complies with their agreement that it will be valid according to the Arbitration Act. And if one of those provisions would be incompatible with that, surely their governing desire is that it will be valid according to the Arbitration Act, not that it will be not valid.
My lord, I would return to the example of an oral agreement. If we had an oral agreement that this is an arbitration according to the Arbitration Act, yes, you would say that the intention of the parties was, but the rest of the contract might not yield to that, and the court might strive to give effect to the rest of the agreement and hold it valid, even though the primary intention could not be fulfilled because it's not in writing. And in my submission, the same is true in this case. If the parties have agreed a consensual contractual mechanism for resolving their disputes, if it turns out that consensual contractual mechanism does not comply with the provisions of the Arbitration Act, then in my submission, the court should strive to give effect to what the parties have agreed they should do. Confident in the fact that such an agreement could still be in force as under an implied obligation.
So if you're right, all that the parties have done so far in terms of the application to enforce was misconceived, your application set aside wasn't necessary, because it would have been necessary.
Yes, madam. I mean,
Section 68 challenge is written water as well, because none of that applies.
Yes, madam. My principal submission is that this is a valid agreement according to the Arbitration Act, and that properly construed it is final and binding. It's not contrary to Section 58(1). And it is an arbitration agreement within Sections 5 and 6, which provides the Beth Din with powers to review its decisions in broad terms and without any specified time limit, but that will still result in ultimately in a final and binding award. My lords, we've dotted about somewhat, so I'm quite close to the end. I just pick a few short points. The argument has been made at Underground 2, to return to the issue of corrections and the language in sections 57(1) and section 57(3). My learned friend took you to a handful of authorities to make the submission that any power must be limited to a power similar to that in sections 57(3)(a) and b. One of those was the Assess Have Silic Service decision, which is at tab 4 of the authorities bundle, starting at page 52. My learned friend took you to paragraph 20 of that decision, which is at page 55. And referred to the fact that by no stretch of the imagination does the power in section 57(3)(a) to correct an award so as to remove any clerical mistake or error arising from an accidental slip or omission to clarify would entitle the tribunal to reconsider its conclusion about the submissions of a party, especially where those submissions have been safely received and accurately recorded in the award. I simply make a point in respect of that submission that the powers in sections 57(3)(a) and 57(3)(b) are quite clearly limited. All of these authorities are about those default powers or equivalent powers. None of them are about a wider power of review, and none of them say that a wider power of review cannot be agreed. Also, just on this point, looking at the text of 57, my learned friend submits that correct must be given a limited meaning. Section 57, your reference again, is tab 24 of the authorities bundle at page 350. But the limited wording, the limiting wording, which is referred to in a number of authorities, is not the language in 57(1). It's not the word correct. It's the language in 57(3)(a) and 3b, principally 3a, correct an award so as to remove any clerical mistake or error arising from an accidental slip or omission, or clarify or remove any ambiguity in the award. So that's the limiting wording in section 57, in the default power in section 57(3)(a. That doesn't mean that to correct has a limited meaning in section 57(1).
Would it cover changing your mind, that when you heard the witnesses you believed what they said, but on reflection you think, oh no, they were lying through their teeth? So I know I said on Monday in the award I accepted witness A and I thought he was truthful and honest. I've changed my mind? And would it cover a situation where he's done something to me after the award which makes me realise he's not a very nice person at all? Would that be correcting?
Yes, my lord, in my submission that could come within the broad meaning of to correct something.
So a change of mind or a change of evidence would be within correcting.
Could do, yes. If a judgment is given which is completely wrong, you might still say it was corrected. There's no specific limited meaning to the English word correct in my submission. There is, of course, for example, under the ICC arbitration rules, there is a power or a requirement rather to, and just for your lordship's reference, that's it's at tab 31 of the bundle. I don't need to turn this out.
Which page of the bundle?
374 of the authorities. There is under those rules under Article 34, a tribunal is required to get the approval of the ICC court before issuing a final award, and the ICC court may suggest changes, including substantive changes. And
that's not correction, is it? Though that's prior to reaching the award. You've got to go to another body, and they will say, "Actually, we don't think that's very good. We think you should look at this."
yes,
That's not correcting it. That's the process leading up to.
well, in my submission, that could still validly be described as as the tribunal correcting itself.
They don't need to. They haven't done anything yet that needs correction.
Yes, but as a matter of English language, my submission is simply that the word to correct can
It's
cover
the English, not the
rules.
rules, really.
Yes.
If the English means including changes of mind or
Yes.
changes of evidence received after.
Yes, my lord. My lord, just one final point on the authorities is in relation to the question of repugnant terms. To draw my lords to the attention of paragraph at tab 36 of the authorities bundle, page 494. And it's paragraph 1686 of Chitty, just the on page 495, the penultimate sentence, to stress that a term may also be rejected if it is repugnant to the main purpose of the contract or the remainder of the contract. However, an effort should be made to give effect to every clause in the agreement and not to reject a clause unless it is manifestly inconsistent with or repugnant to the rest of the agreement. I simply raise that in my submission. The primary goal is to seek an interpretation of the agreement which gives effect to the parties' objective agreement, and it's only as a last resort that something should be struck out as being repugnant.
I think just on that point, there are some authorities to the effect that we should strive to give effect to the parties' agreement. I mean, we've obviously got the commentary from Lord Saville. Is it said in any of the judgments we got in the bundle? That specific. I mean, I don't think we really need it, but if there's a sort of easy quote,
My lord, I'm not sure it's a point which is
no,
specific.
don't worry, we'll find something. But you don't dissent from that proposition.
No, my lord. My lords, unless I can be of any further assistance.
No, thank you very much indeed, Miss Binney.
Thank you, my lord. I have 4 short points to make by way of reply. First, I wanted to deal with the possibility that the parties have contracted out of the Act. And again, I have 4 points under that heading. The first, my lords, is that the task is obviously to identify what it is that the parties have agreed. And that, my lords, they have agreed to arbitrate pursuant to the Act in a manner capable of producing awards enforceable under the Act. That's point 1. Point 2.
Hold on.
Sorry, my lord.
Arbitrate pursuant to the Act leading to an enforceable award.
Yes, my lord.
Sorry, I'm so right. Yep, okay, got that one.
My second point, my lords, is that it's not particularly unusual for the parties to an arbitration agreement to attempt to agree an inconsistent term. And I'll give you 2 examples of where that may happen and how it's dealt with. The first is under section 4 of the Act, so that's at Authorities Bundle tab 18, page 337. My lord, the point here is section 4.1 provides the mandatory provisions of this part are listed in Schedule 1 and have effect notwithstanding any agreement to the contrary. So the point there, my lords, is that the Act, there may be a situation where the parties have tried to contract out of a mandatory provision of the Act. And if that happens, the result is that the term the parties have agreed, the contrary term, is not effective because the mandatory provision has effect regardless. What does not happen, my lords, is that the whole agreement is no longer an arbitration agreement, but it's an agreement for some other kind of contractual dispute resolution process which is outside of the Act. That's the first example. The second example is if a contract contains inconsistent arbitration and jurisdiction clauses. There's no case on that in the bundle, I'm afraid, but there is some commentary on it, again from Lord Justice Foxton writing extrajudicially. That is Authorities Bundle tab 34. Page 446. And I'm particularly hoping to direct your lordships to the bottom, the paragraph. So this is an article by Mr. Justice Foxton, as he then was, I think, about the extent to which arbitration law is in some ways not strictly contractual. At the bottom of page 446, he says one of the ways in which arbitration is not a straightforward contractual exercise, or the construction of the agreement that is that arbitration clauses are clearly privileged over jurisdiction clauses when a contract or a connected set of contracts contains both an arbitration and an exclusive jurisdiction clause. The contractual arrangement will almost invariably be construed as involving an obligation to arbitrate. And at the bottom of that paragraph, over onto the top of page 447, there's a quote from Mr. Justice Cook noting that the English courts, quotes, look to the strong policy in favour of arbitration in addressing this issue. And my lords, that strong policy also means that if your lordships are with me, that a valid arbitration agreement cannot contain this term, the arbitration agreement as a whole must be prioritised. My third point under this heading, my lords, is that if your lordships have found that this agreement with this term is incapable of producing a final award, that award would also not be enforceable as a contract, because for all the same reasons, it would be an uncertain obligation. So that doesn't help my learned friend in my submission. And fourth and finally on this point, it may help lordships to consider what would likely have happened had the appellant sued in court for the outstanding payments under the SPA. And in my submission, had the respondents sought to stay under Section 9, that clearly would have been granted. There is a clear arbitration agreement. If there is no arbitration agreement, that raises the possibility that the appellant could still sue in court and the dispute would continue to rumble on in that way. That's the first overarching point I had in reply, my lords. The second relates to my learned friend's submission that unless there is a contrary mandatory provision, the parties can agree whatever they like. My lords, the parties cannot agree something that is fundamentally inconsistent with arbitration and still have their agreement be an arbitration agreement. It is inherent in arbitration that the tribunal finally resolves the parties' dispute. That is what arbitration is. The present appeal does therefore raise some quite fundamental issues about the nature of arbitration. In my submission, my lords, and this is complicated by the fact that there is no statutory definition of arbitration. Arbitration is a process by which the arbitrators decide the dispute. Once they have decided it, they are functus officio. And I think, my lords, that my learned friend accepts that. Once the tribunal is functus, their jurisdiction is exhausted, and they cannot, the starting point is that they cannot do anything further. Nothing at all. They have no further jurisdiction. Section 57 is an express statutory carve-out to that position. It is the only such carve-out, save in circumstances where an award is remitted by the court. So my learned friend says that your lordships need to look for a provision actively prohibiting the tribunal from making a particular type of change. But my lords, in my submission, that's wrong. The starting position is that the tribunal, having made an award, is functus.
But if the arbitration agreement said they shall make an award, but that award may be reviewed by an application made within 14 days and determined within 28 days, their functions would include award review. And what's wrong with that?
My lord, that kind of agreement may well be construed as an agreement for essentially a draft award. The award hasn't been made until that process has concluded, because the award is sent to the parties, but it's on the basis that there'll be this period where the tribunal will receive further submissions on the award. Once that deadline has passed, or that process has concluded, the award is made in the sense that it is final. So that kind of agreement, I think, would very likely be effective, but that is because it would be in reality for a draft award. Once an award is made, in the sense of the decision is finally made, this is the arbitrator's decision, the tribunal is functus, and it's necessary to find an avenue within the Act which allows the tribunal to exercise some further jurisdiction. Section 57 is one of those, it's the only such provision, and it's a narrow exception to the blanket rule that a tribunal, having decided an issue, is functus officio. It allows the tribunal to do something that it otherwise wouldn't have the jurisdiction to do, which is to change an award that it's made. But that's my second point in reply, my lord. My third point arises a little more from the facts. I'm not going to go into any detail on the facts because in my submission, my lord, it's not relevant to the issues before you today, I wanted to make 2 points. The first is very brief. The communications sent by my client about the substance of the second award. Firstly, they were sent, the ones that I'm aware of that my learned friend has taken you to, were sent within the 28-day period within which the parties would have been able to request corrections if the default regime applies. And in any event, my lord, and this is really the fundamental point, what the parties understood does not change what the Act allows. The parties signed a document saying that the Beth Din could change its award at any time. And perhaps unsurprisingly, they both seem to have thought that the Beth Din did have some kind of review power, perhaps a very wide-ranging review power. The parties are not lawyers, my lords. But they also thought that the arbitration agreement was valid, that it was one to which the Act applied, and that judgment could be entered on it under Section 66. And, my lords, as a matter of English law, those things cannot both be true. So the fact that the parties may have thought they were both true, it is, in my submission, immaterial. The fourth and final point I wanted to make, this again relates to Section 57, which is at tab 24 of the Authorities Bundle, page 350. This is just picking up again at the point about Section 57(4) and the deadline for an application for a review to be made. My lord, the default regime provides both that deadline, so a deadline for the parties to apply for a review, and also in Section 57(5), a deadline by which the corrected award must be provided. And that's 28 days from the request, if there's been a request, or 28 days from the award, if the correction is being made at the tribunal's own initiative. My lords, both deadlines are essential. The second deadline is just as essential as the first. The parties need to know when the award is final, or when they can enforce it, when they can apply to challenge it in court, whatever it may be. And that deadline is necessary to avoid precisely the kind of situation that happened in this case, that a request for a review was made on one particular basis. The appellant then didn't hear further from the Beth Din for 5 months. He applied to enforce the award, and another 3 months after that, a further corrected, amended award was made. And my lords, that cannot be right, that cannot be how the Act is intended to operate. There needs to be a clear deadline after which the parties are certain of their rights and the award is final. Unless I can assist your worship further, those are my submissions to the fair. Thank you.
No, thank you very much indeed. Well, thank you both very much indeed for your excellent submissions. It won't surprise you to know that we're not going to give judgment at 5 to 4, and we will reserve our judgments, and we will then hand down in the usual way. When we do so, there will be the embargoes, which must be respected, because it's always very disappointing to have to deal with contempt of court when dealing with these issues. Thank you all very much indeed.
Court rises able.